it's no longer news that Simon Ekpa has been sentenced to prison in Finland, but obviously he has the option of an appeal. But of course, it all depends on the Finnish court system. But do you see him coming out of this, even if he goes on some kind of appeal?
Well, if he goes on appeal, it's just to review what the High Court has done, the District Court has done. And the job of the Appeal Court is either to affirm the sentence, reduce it, or raise it. So it's a legal risk to go on appeal.
Alright, depending on your time zone and your location, that about Saturday, the 6th day of September 2025. We see no much update the move to the appeal court by the USB government and the consequence. This video with an interview by a particular press media. First of all, I give them credit for putting up this video together. If enjoy with this update to you people for record keeping, Kunune keep record. Yes, and our duty as usual, with us if I follow now the medias and what is actually happening. So this particular video was talking about the consequence, the outcome. Mobruna, the team of Man Simon Ekpa's legal team move to the appeal court to actually appeal this process. Unuman brought the news that now the CCA jail term is still there, and the next move by the USB government and legal team Simon Ekpa concerning the move to the appeal court. Una forgotten the latest updates where Pan-Africa where they are challenging the outcome of that court ruling by the Päijät-Häme District Court in Finland. So I want you guys to watch this video with an open mind. Just watch the video critically. Pin some points down. This conversation was actually all about. I don't want to say much. Watch the video, share your thoughts and opinions on the comment section, and do well to also share the video. Candace always super for this update. Watch the rest of the video, guys. I will be right back.
Because from every indication, he is guilty of what he's charged with. He is guilty of inciting people to violence in Nigeria while staying at Finland. He is guilty of amassing a lot of wealth from contributors who believe in the Biafran cause he was pursuing. And when you have such influx of money into a particular account in a country, there's a legal liability to explain the source and also to pay tax. So I do not think he complied with these laws, and that is why he's also been charged with, he was charged with aggravated tax offenses. So it's not like he's innocent. He's quite guilty of what he's charged. So the appeal court will only review whether the essential rules of procedure was complied with, whether the rules of fair hearing was complied with, whether he had a lawyer who represented him, and whether the lawyer was allowed to make a representation, a legal representation for him in his defense. So if the appeal court says that all these were complied with, I do not see the appeal court tampering with the verdict of the district court. And talking about its impact on Nnamdi Kanu, I do not see any connection, because the decision of the Finnish court is not binding on any court in Nigeria. Nigeria operates a principle of judicial precedent in our system. Judicial precedent means lower courts are bound by the decisions of the high court. A district court in Finland is equivalent to a high court in Nigeria. And there's no way a decision in Finland can bind the high court in Nigeria. Having said that, I would also say that the issue of adjudication of cases depends on a particular judge. The way one judge sees a matter may not be the same way another judge sees a matter. Judges are human beings, and most of the cases they decide depend on their general worldview and their peculiar personal experiences in life. For instance, if a judge is a woman who is a divorcee, and then you have a divorce case before that woman who is a judge, the man may not get a fair deal, because the judge will always form an opinion that these people have come again. That's the way they behave.
Through past experience.
Through past experience. So no man can get a fair deal before a judge who is a product of a failed marriage. Because, of course, you always see in the man a replica of her former estranged husband. So that is how it is. The district court in Finland cannot affect the decision of the High Court of Federal High Court of Nigeria. The decision that is coming on October is about no case submission. The judge has to look at the case before it, look at the evidence that has been tendered, and then also look at the manner in which he was extradited from Kenya, which is against all known international law on extradition. Nigeria was reckless and irresponsible in the way it handled the extradition of Nnamdi Kanu from Kenya. And the Court of Appeal had already said that that reckless display of arrogant power by Nigeria, not following the internationally accepted procedure of extradition by going to Kenya to seek order of court in Kenya to extradite him to Nigeria to face trial, and going there to abduct him, kidnap him like a criminal. If the judge is minded to follow the earlier Court of Appeal decision, he can rule in his favor. If the judge is somebody who is grounded on international human rights principles, if the judge understands what the United Nations have already done over the years from 1945 all the way down to our way, through many multilateral treaties talking about human rights and the right of people of all nations to seek self-determination. The right of people to seek self-determination. Self-determination means, according to Article 1 of the International Covenant on Civil and Political Rights, and Article 1 of International Covenant on Economic, Social, and Cultural Rights, they define self-determination as the right of all people to freely choose their political status anywhere they are, and the right to choose their economic, social, and cultural development. That means if a group of people, a tribe of people, an ethnic group in any nationality or any sovereign nation is feeling shortchanged, is feeling that they are not being fairly treated according to the law of the land, is feeling that there's a systematic marginalization of the group, they have a right to seek self-determination under human rights instruments that I have quoted. Even the African Charter on Human and People's Rights have also confirmed in Article 20 the right to self-determination. But this right does not guarantee or empower anybody or permit anybody to pick up arms against a sovereign state, which Ekpa appears to have done. So in that regard, Nnamdi Kanu, if the judge knows about all these human rights treaties I've mentioned and its implication in this trial, is likely to consider the case of Nnamdi Kanu favorably towards him.
We'll come back to Nnamdi Kanu's case, but let's dwell a bit on Simon Ekpa's case. Do you think that how things have ended with him, especially now with the district court in Finland, that it will serve as a deterrent to anyone who's trying to rear their head to cause any form of trouble using the name of IPOB or Biafra or anything?
It is a certain warning signal to everybody all over the world that the long arm of the law will always catch up with you, as long as you do not comply with the rule of engagement anywhere you are. When you are fighting for liberation, when you are fighting for freedom, there are permissible things you can do, and there are things that are not permissible under international law, and especially under the national law where you are living. So when you fight for freedom, you must be conscious of the position of the law where you live. Most nations of the world now will not take it kindly to anybody inciting violence or inciting terrorism. Terrorism is an international crime, and nobody can sit anywhere in the world and incite people to violence against a sovereign state anywhere in the world. So people who stay outside Africa and feel that they are in safe haven and that the long arm of the law cannot reach them, they should remember that even in their country of domicile, the long arm of the law is there. Because when you sit there and incite violence in another country like Nigeria, if it were a country where Nigeria has a bilateral relations on extradition, it would have been taken in long ago. But because there was no such bilateral relations with Finland, and it takes a lot of diplomatic sojourning for you to come into such a bilateral relationship. That is why, instead of sending him to Nigeria, when there's no enabling law to do that, Finland decided to investigate him and take him up on the areas of his domestic laws that he has violated. And that has ended him 6 years sentence. So it's a warning to everybody, freedom fighters, anybody who seeks self-determination, that there are legally permissible limits you must not transcend.
But how do you think that Simon Ekpa got it wrong?
Well, he got it wrong by adopting violent resistance. Non-violent resistance is a permissible rule of engagement in all movement, freedom movement. It was practiced in India by Mahatma Gandhi, who mobilized his people against the British authority in India because they wanted independence, they wanted self-determination, they want to rule themselves as Indians. He mobilized their people to adopt various forms of civil resistance, which included strikes, sit-in, boycott, but not violent resistance. So even when the British authority attacked them violently, they refused to pick up arms against the authority. And in the end, they succeeded, because he said that no matter how long the night, it must break into day. And the model set by Mahatma Gandhi in India, non-violent resistance, was also adopted by Martin Luther King in the United States in the 50s and 60s, when he mobilized the black Americans to resist the segregation that was part of the American system in those days. The black Americans were not allowed to vote. They were not allowed to share public facilities with white people. So they had a different school for the blacks, different school for the white, different school for the mixed colored. And you cannot go to any restaurant to eat. You must go to that of the black. If you enter any public bus, you have to go to the back. You don't sit in the front or middle. This set of segregation that was a form of racial discrimination against the black Americans. Rather than pick up arms or encourage people to pick up arms, Martin Luther King enjoined the black Americans to adopt non-violent resistance. And he educated his followers on the principles of non-violent resistance, one of which is that you must be prepared to endure hardship, endure tribulation, without losing focus on the goal that you are set to achieve, which is the goal of freedom. So where he got it wrong was that IPOB was founded on the principle of non-violent resistance, of the marginalization, unfair Nigerian system against the Igbo race. That is the IPOB, the same principle on which MASOP was founded. Now, when Nnamdi Kanu was taken in, he lost hope or confidence in the non-violent movement, and now decided that it was only by violent resistance that he could achieve his goal. And this violent resistance was based on deceit and fraud, because he was telling his followers that there was a warship somewhere that was preparing to attack Nigeria. There was a fighter jet somewhere that would attack Nigeria and liberate the Biafran people. All these were lies. And then the young men in southern Nigeria put faith in these promises and representations and went haywire. When they said sit at home is one of the ways of demonstrating non-violent resistance. Mahatma Gandhi called it a kind of civil unrest. You can sit at home, nobody will disturb you, as a way of protest. But now, where he got it wrong was now to say that anybody that did not sit at home must be killed. And then you see people getting killed, you see people, shops getting burnt, and people's vehicles getting destroyed because they were not sitting at home on Monday. That was where he got it wrong. So deflecting from the non-violent movement of IPOB and forming his own Biafran Liberation Army to engage Nigerian state with a kinetic energy, it is where he got it wrong. And that is where he has been cited in Finland for inciting violence in another country.
So, I mean, typically now that he's been shut down, there is now nobody that will be dictating what will happen especially for those who are hiding behind the struggle to perpetrate crime here in the Southeast. Do you think that maybe some of those issues that were rearing their heads in the Southeast because of the calls Simon Ekpa has been making in the past, that maybe it's time to actually forget all that? At least Mondays can be easier than they are before.
Yes, it depends on how Nigerian state handles it. Because all these young men who were members of his liberation army were paid stipends by him. He amassed a lot of wealth from contributors all over the world who were supporting the Biafran struggle. And he was giving these young men, paying them stipends per month. And nobody is paying them that now. So that void that has been created, the young men had to get busy. And now they are busy in the bushes kidnapping people and making money. So the rate of kidnapping in the East has doubled because the person that was giving them stipend on which they were living in was no more. He has been taken in. So if Nigerian state can be responsible a little to fill this gap by using the system that Musa Yar'Adua used in Nigeria when he was president, by this kind of thing was, this situation of kidnapping and all manner of lawlessness was going on in Niger Delta. And rather than engaging them with kinetic energy, he resorted for dialogue, met with them, and came up with this idea of giving them amnesty. And you see that amnesty program worked very well in Niger Delta. We don't have all that kind of unrest anymore in Niger Delta. If the federal government can be wise enough to engage this youth on a dialogue, bring them together, and see whether they can lay down their arms for an amnesty, now that their leader has been taken away, then it will help to check the escalating insecurity in the Southeast. Because anything other than that, these men are still in the bushes, they are still wreaking havoc on the civil populace, and there's nobody stopping them. Engaging them with the police and the army does not solve any problem. What will solve any problem is for the federal government to extend an olive leaf to them, to encourage them to come out and kind of pacify them with a form of amnesty. After all, the Biafran agitation is about unfair treatment the Igbo race is undergoing in Nigeria. Systematic marginalization over the years. And these things can be seen easily. What stops the federal government from calling these agitators and knowing exactly what are these areas of marginalization that they want to be corrected, and taking policy decisions to solve all these issues, and then trying to resettle these young men, taking their arms and resettling them in the way that they will become productive for the society. Many of them are graduates. Since they graduated, they don't have any work to do. There's a systematic discrimination against the Igbo youth in federal employment, and state employment is not sufficient to go around. So the best way is to engage these people to fill the void that the absence of someone has created, so that we can now mop up these youths and see whether we can get them usefully engaged and radicalize them and put them to better use.